Hi everyone, it's Jeff Cohen and Carlos Arce from the Florida Healthcare Law Firm. Thanks for joining us on these podcasts where we're going to keep you informed of all the healthcare legal developments in your industry so that you can be safe and successful. What's up with the whole white shirt? Dude, you're wearing jeans too. What's up with that? I am too.
I wasn't trying to go for the Jeff Cohen look,
Right.
which is usually darker colors,
Right.
jeans. So I said, let me wear white, and then here you are.
It's so weird.
Just trying to brighten up your day.
I feel like a waiter, like we're wearing a uniform.
Yeah.
You need like one of those like dark apron things that guys wear when they wait on tables. That's what I think we look like. Anyway, well, we dress oddly alike.
Correct.
And that's probably just a reflection of the fact that we like to talk about the same stuff all the time.
Right.
Yeah, there you go. So what are we talking about today? What's the
So we're talking about House Bill 837. So
and that's in the Florida legislature?
That's in the Florida legislature. It was just passed March 24th, 2022. Sorry, 2023. Let me get my dates right. Yeah, the 24th. It went into effect and it went into law. I received a lot of calls from clients requesting to have something of this nature, speaking about the House bill and the changes that came along, because they're concerned. Because
what kind of folks are affected by this? Is it physicians? Is it chiropractors? I mean, who's really hit most?
It's mostly MDs, DOs, chiropractors, mostly chiropractors because, the way that in a car accident, it's usually the stream of providers is hospital, primary, or chiro, and then it goes to some sort of specialist.
Right.
So typically what happens is the chiros and the providers get stuck into the PIP box. So meaning personal injury protection benefits, that's where they're getting their money for the bulk of the treatment that they're doing because they're one of the first responders for somebody that's been injured in a vehicle accident.
So this law really targets PIP providers more than anything else.
It does. Okay. It does, and it also targets personal injury in the industry as a whole.
Okay, so what's the big smack? And then take us through how it really impacts.
Let's start with this. The statute went into place March 24th, 2023. So what that means is that any insurance policies that were in effect prior to that will not be affected. Any injuries that are after that date, however, would be affected by it. So let's say you had an accident prior to the date of effect, you had an insurance policy that gave you coverage, you still have benefits.
So prior to what date?
Prior to March 24th, 2023.
Got it. So everything that you're going to talk about in terms of the impact on physicians is post that date?
Correct.
Okay, cool.
Right.
So tell us what happened.
I want to give a brief summary on the law.
Okay.
I've seen that a lot of things online are targeting essentially from the standpoint of attorneys that are in the industry, and they're talking a lot about how it's going to affect them because it does affect attorneys that are in the space. But I haven't seen really a lot of content that's talking about what affects medical providers. When I'm talking medical providers, I'm talking about MDs, DOs, chiros, orthos, doctors that tend to work in the space of PIP and then LOP, meaning letters of protection.
Right.
Okay? So what has happened is the attorney fees calculation has now gone to a lodestar fee, which means it's the calculation that attorneys will be able to recover on is the actual time spent times the rate that a court designates them as their reasonable amount.
So do you think that's going to be less than they're used to getting or more than they're used to getting?
I think that's going to be less, and I think that that's going to diminish the amount of claims brought under PIP because lawyers now won't be able to recover right on filing suit. Typically, if you have a good case and there's some sort of bad faith, which is also spoken about in the statute, the lawyer gets to recover attorney fees, and it used to be like a bulk amount. So it would range anything between $2,500 to $4,500 depending on the experience of the attorney, their involvement, their notoriety with the insurance carrier. Now that's not the case. It's your actual time billed and reasonableness, and a trier of fact will determine that. So what does that mean? If you spent 30 minutes, you're getting 30 minutes.
Wow.
Before, you would have a legal assistant who would prepare these demand letters and you would sign off on them and you were using them, and the statute actually goes as far as explaining what a legal assistant is and what they do and what they know that they should be doing.
So you think this will maybe price some of those lawyers out of the market? It won't be so lucrative? Yeah.
I do. This will also affect attorneys as they recover in personal injury lawsuits. If there is a sort of attorney fees clause, this also affected premises liability. So property was also spoken about. Real property was actually spoken about in the statute as well. So there was a change to that as well. Well, we're not going to speak about that because that's not our area. You know, we speak about healthcare providers. That's our clientele.
Cool.
So the statute of limitations for negligence has now been reduced from 4 years to 2 years. What does that mean? Well, that means that if somebody, let's say, slips and falls in a Publix parking lot, it's not 4 years anymore that you have to bring a claim. You've got 2 years.
Wow. So that really shortens the amount of time that people have to act on these injuries.
Right.
Okay.
Right. It doesn't leave. As it relates to our healthcare providers, in my experience, I did a lot of medical malpractice. I would see when plaintiff attorneys were suing under negligence, they would always try to go through negligence because there's no tolling statute, there's no pre-suit requirement. It's a lot easier to get it through the courts. So they were always trying to make the argument that it was negligence and bypassing medical malpractice, the statute that relates. Now cutting it down to 2 years, medical malpractice is 2 years. Negligence is 2 years. So pick the poison, but nonetheless, you're going for 2 years. That was like a pass-through people were doing prior. Bad faith, that was another issue that was raised. Insurance carriers typically would pay you a certain amount of money. Let's say you invoiced a bill for $1,500, and they said that we're going to tender $1. And they would say, well, we're under review because we think that the claim is not reasonable or whatever it is that they may be not paying for. Typically, that used to be a bad faith claim. You would sue under bad faith, which would allow you to have a PIP suit under bad faith. Now, that's not the case. That's been reduced. Now the insurance carrier has the right to flag something, has the right to pay minimal amount, and that's not considered bad faith. So that basically limits the amount of lawsuits. Maybe that was 25% of PIP suits. Last time when I was involved in PIP, I think that was the amount of lawsuits in the pipe. But now that's been reduced. So that's no longer a way to get to PIP suits. Also reducing the amount of suits. Comparative negligence. So Florida typically was a state where if you sued and you were injured, you could still recover even if you were at some liable for the injury.
Right.
That has now been changed to comparative negligence, which means if you have some sort of fault, that goes against you in the amount of your recovery.
So if you're 50% at fault, then half that recovery isn't yours.
Well, the statute goes as far as saying if you're more than 50%, you can't recover at all.
At all? Wow.
That will be big because what we were seeing in the market was people were having rear end accidents.
Right.
Okay, so you're at fault. You rear end somebody. Okay, you were saying, oh, I hurt my neck, I hurt my back because I did this. Right.
Right.
That's not a way to recover now, because if you're at fault and you should have been paying attention and you hit the person and there's some sort of liability on you that 60% of it was you weren't operating the vehicle in the proper manner, you weren't having the proper spacing, all the things that are used in court by experts to diagnose whether you're at fault or not. If you're more than 50, sorry, can't recover.
So there's going to be a huge industry that emerges to try to push the contributory negligence past 50%, so they shut those suits down, I would think.
Right.
Right.
Right. So this is going to open up basically for, I think, experts that are in the comparative negligence space, the ones that are doing those diagnoses of, those people are going to have a lot more business.
Yeah.
But it will be more challenging for providers. Why do I talk about it? It's because providers will be affected by this. Why? Well, as a provider, you're treating somebody and you're not really worried about the legal analysis. You're a physician, you're a provider, you're there to render treatment. You're hoping you're going to recover either through PIP or somehow an LOP if you end up getting into one.
Yep.
Since those are all being reduced now, what are your chances of treating someone and maybe not getting paid anything? It's very likely. And what the statute is saying that your next source of recovery should be their commercial policy. They're calling it the healthcare coverage, meaning if you have some sort of commercial insurance. So it's pretty widespread law that you have to carry commercial insurance for healthcare. You have to have it under the Affordable Care Act. That was one of the requirements. You needed to have some sort of insurance, whether it be marketplace, if you were someone that didn't meet the income requirement, or you get it through your employer, or you got it, you paid for your own policy. Fair. That everybody knows that, right? That means that commercial plan now will be the next resource to getting paid. What does this mean for providers? Many chiros, and I'm singling chiros because I know, because those are a lot of my clients, don't have commercial insurance.
That's right. They're not on the panels.
They're not on the panels.
Yeah.
They're opted into Medicare because it's required.
Right.
They bill PIP because that's the business.
But they're out of network for commercial.
That's right. So what happens now? Now what happens is they have to be forced to bill the claim to commercial. And if there is no commercial, then they got to go to Medicare. There's no Medicare, then they got to go to Medicaid. And they've outlined what is the amount of recovery they can have.
Wow. This is huge.
It's huge.
It's huge. So it's really squeezing both the patients out of the client funnel for the personal injury lawyers, and it's squeezing the providers out of the space because it's no longer as lucrative as it used to be.
Yes.
I mean, physicians have always been willing to delay bills and take the risk on the LOP or in any kind of an accident case because they figured, you know what, it's better than what I'm getting on the commercial side. They're not even paying me enough to keep the lights on on the commercial side. And on an out-of-network basis, which a lot of these physicians are, as you mentioned, they're not able to get in network, and even if they were, they're below market rates.
Right.
So they're saying, now I'm going to delay the ability to get paid and take the risk that maybe the lawsuit goes bad so I don't get paid at all in order to get what? A fraction of what they used to get.
Right.
Wow.
So
this is huge. And I assume it was the intent of the legislators to really squeeze the heck out of the PIP industry.
And it was. And a lot of the argument that was platformed in the House when they were talking about the bill was saying that this was for reasons of reducing the amount that Floridians had to pay in this type of insurance, and that was the argument. It was like a public policy argument that we needed to make this happen.
So we're going to get all kinds of refunds to our PIP and to our automobile insurance?
That is.
I don't think so, brother. I don't think we're getting a penny back.
That's a lot of the questions that the attorneys that are fighting against, a lot of the big house law firms that you've probably seen on billboards are filing suits saying that this is unconstitutional for purposes of limitation. Let's go deeper into what's the amount that you can recover. So typically under an LOP, letter of protection, you would submit your invoices to the attorney. The attorney would compile the bills, would create a demand, and then would send it out to the carrier. The carrier would then agree or not agree, and you at that point would settle or you went to trial, right? Prior to this, LOPs were not they weren't admissible because of the attorney-client privilege. Attorneys would always be the ones that engaged the letter of protection on behalf of the client and with the client, so they would cover it through attorney-client privilege. I remember in my previous world when I used to work defense for one of the big players, there was case law that we would always cite that said if the LOP was not given by the lawyer, then we would be able to get it admissible because that would show, look how much the bill is inflated. Well, they don't need the case anymore. Now they got the pure statute. The LOP is admissible, the whole thing. So what they're saying is you have to itemize in the LOP the amount that you're actually billing.
Which has never been done.
Has never been done.
Right.
So bills under, if you're a healthcare provider, you have to bill properly according to CPT regs, Healthcare Common Procedure Coding Systems, HCPCS. So what does that mean? If you're someone that's not used to being, let's say, in the primary care space or in the regular medicine space, when I mean regular medicine, I'm talking non-PI, right? Non-injury. You're going to have to teach yourself how to bill properly. And most chiros don't have in-house billing.
No.
They don't have in-house coders. That's a function for primary care provider specialists.
And even the physicians that are dedicated entirely or largely to PIP space, neurosurgeons, orthopedists, and neurologists, some of the other folks that really concentrate in that space, they're not as attentive to the whole HIC-PIC issue or the CPT issues when they're dealing with these patients. And now they're going to basically have to treat these patients for coding purposes as though it's a Medicare patient.
Right. And I'm doing some forward thinking here, Jeff. Let's talk about how false claims will implicate this. If the standard is saying you need to bill CPT, you need to bill HCPCS, and you don't, is that a false claim?
Right. So it opens
I think so.
So it opens the door for the payer
The SIU
to
now
say, you
is
know
at
what?
the door.
Now we got to chew on your heels. You got it wrong.
Yeah.
It's a False Claims Act violation.
Yes.
I think you're right.
Yeah.
Yeah.
And you know, typically SIU was getting involved like in PIP suits, right? Because they would itemize the claim. You would send in your HICVA 1500, right? That was the procedure.
Right.
You would get an EOB back, and then it would say, we're denying this code, or we're accepting this code, right? Under LLP, you used to put in as many codes as you could for whatever it was that you were rendering. And granted, I mean, they had a point. Like, some stuff was inflated. Let's be honest. Some things, people were abusing it. They were. It's just ruined it for the rest of the good guys, because now you're gonna have to do it this way. So it just won't be as lucrative as it once was. So LLPs are no longer the bypass.
But I get the plaintiff's lawyer's concern on the constitutional side, because we have a state constitutional right of access to the court system.
Right.
And that's, I assume, what they're going to argue, that, you know what, it's unconstitutional in Florida because essentially what you're doing is restricting a patient's access to legal redress, which has always been the card that they play when they're dealing with med mal reform, especially. So it's the same thing.
So the other thing that's going to be affected now is the factoring companies. So what are factoring companies? So typically in the personal injury space over the last, I'd say 5 to 10 years, there's these companies called factoring companies. And what they were doing was, when a personal injury suit was being brought and there were certain bills that were being rung up through an LOP, you know, these cases can take 2 to 3 years, okay? So these factoring companies were buying the receivables essentially at a discount, and they were waiting to recover, and that's how they made their profit. So what they were doing was almost like an advance of the bills.
Yeah, we'll pay you a fraction of what you think you're owed, and we'll take it from there.
And they were doing this for the purpose of helping, I guess, people that are less fortunate, that are engaging in this type of injury treatment plan, because, you know, you have to miss work, you have to go to many visits, you treat with a chiro 20 times, ortho 20 times, repeated imaging, you know, if you have brain injuries, you gotta go to a brain doctor. So it's very difficult for people that have a 9 to 5 that have to bill, and not have to bill, I'm sorry. They have to basically, they're hourly, you know, and then, you know, there's only so many doctor visits you can go to right before your employer is looking at you kind of funny. So a lot of people through these factoring companies were getting paid basically money in advance. It was given to the patient. The attorney would then give it to the patient and say, this is money you're going to get, essentially, we're fast forwarding it for you. Okay? Well, that now has to be disclosed. Before, that wasn't a part of the lawsuit. That was under attorney-client privilege. Now, you must disclose the name of the factoring company, the amount, including any discounts given. You must identify the healthcare insurance coverage if it was available at the time that the medical treatment was received. Why is that? Well, they're trying to avoid, if you keep boosting up the bill, and there's a likelihood that that's not going to get paid, you should have been using healthcare coverage. So they want to know, was there coverage at the time that you were ringing up these bills? And if so, they should be on the hook to pay for it.
You know, there's also a provision in the insurance code in 627 that says when you submit a claim and you've agreed to a discount at the time a service is being rendered, you have to reveal the discount on the HCVA 1500 form.
Right.
So if the timing on the factoring issue isn't handled precisely correct, now you have an inaccurate bill, possible False Claims Act violation, and the ability of the insurance company to say, you know what, we're not paying you full bill charges, we're paying you discounted charges, which means that it's a pass-through to the factoring company.
Right.
Wow.
Right. And,
that's huge.
And look, in the commercial world, when you're giving discounts, you know, you're not attributing that you're not charging for the copay or coinsurance or whatever that may be. That's a false claims. So, and they always raise it. So now the PIP carriers have gotten, or let's call them the personal injury carriers, have gotten smart, and they're like, oh, Cigna, Humana, Aetna, Florida Blue, you're doing that? We're going to do that too. It works for us as well. You give a discount, we want to know about it. So just another reason why enforcement and knowledge on healthcare laws will be ever more important to anyone that survives and stays in the industry. You know, typically a lot of providers in this space don't have compliance plans. They don't have policies and procedures. Billing practices. Like we said, that's typically reserved, or people
Right.
usually did it personally in the primary care space, or in the specialist space, or in the facility space, hospitals.
Because there was always this kind of bifurcation in the injury space versus the pure medical space.
Right.
The traditional medical folks know about things like ABNs.
Right.
They know about the Incident to Services rule. They know about direct supervision requirements and things like that are part of our daily fare. But the folks that were primarily serving the personal injury space figured, you know what? We don't need to really strictly comply with CPT or HCPC, Incident to Services provider. We don't need to know anything about healthcare laws that apply to things like designated health services or anything like that. They would say, you know what? The reason why I'm in the injury space is because it's simpler, it's easier. And now what they're doing is they're weaving these two regulatory environments together.
Right. I also think that with, and this just came to a thought to me as we're speaking about it, I think that the need to now disclose all the providers on the LOP, all the services rendered, who are the providers, you're billing it traditionally, that's also going to raise potentially healthcare clinic violations. Because let's be real, a lot of people that are in this space were operating without licenses at times, and maybe the statute said it needed to be a healthcare clinic. And maybe they weren't, because somehow the structure isn't compliant that requires you to be a healthcare clinic.
Right.
Now, when you're basically attesting on these statements, this center serviced this bill, made this invoice, what is the carrier going to do? Well, we're going to go search them up, look at the MPI, check them out, look and make sure, are they properly licensed? Should we go check the ACA the ACA licensure search?
I mean, we see it all the time. Because how many clients have called you and said, yeah, I've been advised by my friend Bernie, the attorney, I don't need a healthcare clinic license. I don't need an ACA license. And he's a lawyer, so he must know. And then you look and you go, dude, you've got a serious exposure problem. Yep. We need to redo your entire business platform so you're compliant because you got incorrect advice.
Right.
Yeah, that happens all the time with us.
It does, and we get it on two angles. We get it either something's come up where the provider is questioning because somebody's telling them we're not going to pay you because of licensure. They come to us for that, or they'll come to us when it's too late. Once they're already under investigation, and SIU has already retained outside counsel, and now they've got their teeth into you. Now it's just too late at that point. At that point, it's kind of like enter into, like in traditional medicine, a CIA. Enter into some sort of agreement.
It's like putting your gloves on after you've been punched in the face.
Right.
It's not good timing.
Right. Right.
Yeah.
So it makes it difficult,
Right.
and it's not operating outside of the scope of being licensed with a healthcare clinic license. There's not much wiggle room. So it's important to have legal counsel that understands how to navigate that and what you need to get and how you got to be compliant. If at all you take anything from this, it's start looking into, are you compliant or not? Because the drape has been unveiled and the Wizard of Oz has been exposed, is to paraphrase it. I just think that now is more than ever the time. If you're going to be in this space, be compliant because they're coming for you. Which leads me to...
Can I interject there? One of the things that you and I say a lot, and that we talk with clients a lot about, is this idea of measuring twice, cutting once. A lot of healthcare professionals and healthcare businesses tend to stay in a reactive mode relative to healthcare legal enforcement. They figure everything's okay. They haven't looked at their compliance situation for a long time. And they figured, well, the advice that we got 5 years ago, 10 years ago, I'm sure is fine. And we're not getting a knock on the door. So we'll deal with it if we have to, is the usual way that they do it. The problem with that is that healthcare law and healthcare business is changing every 5 minutes. Mm-hmm. And if they're not up on it, if they don't ask somebody, hey, can you take a look at what we're doing so that we can position ourselves for compliance and possibly avoid a knock on the door? If they don't do that, they're going to end up in trouble and possibly jam up their business flow. Yeah. Because when that happens and they do get SIU'd, especially if it gets referred out to outside counsel, it is it's a battle. It's a battle, and it interferes with business operations, and they can red flag them and freeze them, and now they have a problem. And then what they'll do, I mean, we've seen this a lot, where they will rob Peter to pay Paul. They'll say, you owe us $100,000, and all of a sudden they start offsetting all their ongoing claims. Right. So it's a nightmare, and they might say, hey, legally you don't have the right to do that, payer, but you don't want to be in that position when your cash flow got dried up.
Right.
Yeah.
Right. And you know, I think that as it relates to like commercial insurance, typically when you're a network, you have a contract, right? So there's provisions on how you can dispute audits, you can dispute denied claims. You've got rights, right? Not the best rights. At times we see that it's difficult because, you know, I think the insurance companies write the laws, unfortunately, and you just got what you got, right? But for PIP, it's even worse because there is no contract. It's basically you attest to the Office of Insurance that you're going to bill PIP and you're going to comply with all the statutes, and the statutes basically enumerate the rights the carrier has. That's how it works. And I think providers at times miss that part, that they don't understand that, well, how can they do all this? Well, I can tell you why they can do all this, because the statute, how you build, you may have read the top part that says, I can bill because I'm a 458, meaning an MD. But it doesn't say insurance can do these things to not pay. That's the policy.
Right.
And it's unfortunately, it's through a law, not through a contract. Even worse, because now it's the law of the land.
And when you're dealing with the legislative process and you have insurance companies on one side that are aligned on these issues and patients that don't have lobbyists, except for perhaps the Academy of Florida Trial Lawyers or the Florida Medical Association to some extent, it's not a level playing field.
Right.
Yeah.
Right. So I think that, well, let me finish up with the law, because I want to talk about solutions, because I think that our clients are worried and they're asking us the question of, what can I do? Right. But so let's finish up here as it relates to medical providers. So now referrals under LOPs must be disclosed. So if a provider, let's say an ortho, now sent you for PT, that referral that was done needs to be disclosed in the LOP. This guy sent me to this guy. So what are they doing that for? They're doing that to show when a medical provider gets called to trial in a personal injury lawsuit. What typically ends up happening is the provider goes up there, they ask him a series of questions. They ask him, where'd you go to school? What are your credentials? Et cetera, et cetera. And then they'll start to ask them questions like, well, where do you get typically all your business from? They're trying to show a chain of bias.
Right.
It's what they were trying to do. That's what the defense lawyer does for the insurance company. This now, what this will create was a doctor, a provider, will now have their integrity questioned. Because let's say that 40% of their business comes from Dr. Smith down the street. That's exposed now. And now, for purposes of trial, they're going to say, oh, you see? This is why he's testifying this way. This is why he's saying this person is so injured. It's because he's got a stake in it. That's alarming, because previously, you used to be able to object, and there was things that you could do, and there was methods in court. But I'm sure once we see this come into trials, this stuff's going to get cited, and we're going to see how that's going to fall. Because
and lawyers used to try to protect their physician clients from that line of inquiry.
Right.
Right.
Right. But now they've opened up and they're availed because of the exposure of the disclosure requirements under the LOP. The last thing will be damages. So damages cannot exceed the actual value of the medical care rendered.
Wow.
That's big, because typically the way that a lawsuit was filed is you would say, I need policy limits, 100,000. There's maybe 60,000 in medical, but there's foreseeable damages for the future. Patient's going to need X, Y, and Z, so we need full tender of policy, and there's going to be more needed. We're going to get it from somewhere else. That was kind of the negotiation tool. Well, now you got to itemize. Now you got to say what the actual bill is. So futures now have to go through a scrutiny process. Where before it was kind of like a given. You would say tender policy limits. The insurance carrier would think and say, well, maybe we should just do it so we save on legal. It's kind of the strategy usually, right? Now it's kind of going to say, no, let's go all the way. Let's see what the bill says. Let's see what you got really in damages. So you're going to need to get a lot of treatment to get it to about a $100,000 policy. Where before, the amount of treatment you would get was not as much as like in the typical billing practices. It was always kind of, I don't want to say the word inflated because it's not fair to those providers that are in that space. It is, you would always overestimate because you knew you were going to get reduced. Now it's got to be actual. That again is going to raise a false claims issue. Then again, we're going back to that. But in essence, this is and like I said, the Act also talks about changes to the property statute and premises liability. We're not going to talk about that, but there's a whole like maybe 20 pages of it, 15 pages of it is about that. But I think it's important that our providers be aware that these changes are coming if they don't already know. They're getting the proper legal advice. I don't want to say that PIP lawyers or personal injury lawyers don't know about healthcare laws because some are in tune and some are seeking the right advice, and they do. But sometimes lawyers are talking without knowing what they're talking about. And I know that because I get clients who come with advice that I'm like, where did you hear that? Well, this guy, that's my friend, that's a referral source, told me this. And I'm like, wow, he hurt you.
Yeah.
And now I have to clean it up. And, I'm glad to, but sometimes it's too late. And then I have to see, like, my clients that are providers, see them suffering because now they got to deal with these problems and they were too late. And they should have had the right legal advice on the onset. Yeah.
The whole terrain in this area has been completely morphed.
Yeah.
By the legislature.
Right.
And if they want to know how to traverse it, successfully with really low risk, they're going to have to take a step back, take a pause, analyze the new landscape, and figure out how to survive and thrive in it.
Right.
Yeah.
Right. Jeff, when we render legal advice here at the Florida Healthcare Law Firm, the way we do it is we always talk about the options, the laws, the options, the risks, and the landscape. Why? Because if we just give you the laws and possibly some options, we're basically giving you a loaded gun to go hurt yourself. If I can't tell you the risks that those laws have implications with and how the landscape, meaning how those laws are being treated in the real world, then you would never know.
Right.
So that is and that's the part that I feel that providers need to know, that they need to seek proper legal advice and not think, well, I consulted a friend that's a lawyer and they maybe in passing told me this is what I think. That's not enough.
Right.
You need to go all the way. You're in the medical industry. It's expected of you. Unfortunately, that's just the way it is. We don't make the laws. We just live under them. Yeah,
it's a great point. One of the biggest differentiations I try to make for our clients is that when you're looking for legal advice, you need somebody that takes you through the laws, the options, the risks of each option, and the landscape within which each of those laws arise. Mm-hmm. Because sometimes the laws on paper say one thing, but the way they're construed by regulators, completely different. And so we ask people, hey, I know you have a question about this agreement, and I know you think there's a very simple answer to your question. But the truth is, if you don't understand the landscape, if you don't understand a process that takes maybe an hour, that is the laws, the options, the risks, and the landscape, then you can't really fully appreciate the information we're conveying to you. And we want you to really be empowered to make good business decisions that help you stay safe. I know at one point in your career, you worked on behalf of one of the large PIP carriers, and obviously you haven't for years. You work on the healthcare regulatory and corporate side, making sure that people get business deals correct and they buy and sell stuff and employ people and create businesses and all that stuff. What made you get out of the PIP defense field? What had you shifting course?
So when I worked in the industry, one of the, I think the monumental event that occurred was there was a person that was injured in a suit, and I was defending one of the carriers, and I saw the bills that she had incurred from the accident, and it's a beautiful girl, very young, and it was a motorcycle case, and it didn't feel right to me that I was trying to essentially diminish at all costs the value of the medical care that she had received. And it impacted me because she was never the same. She had a bunch of replacements, hip replacement, a full rib cage rebuilt. I mean, it was really bad.
Young woman,
22 years old girl, and she, you know, it hurt me to like emotionally because I was thinking to myself, am I really a good guy right now? Am I really for the people? And am I, you know, am I doing the right thing? And for me, it was just a moral tribulation, and that's why I had to get out because I didn't think I could be fighting against getting people the value of what they needed for medical care. Not saying that there wasn't bad actors, because there were, and I felt righteous in that fight because I'm all about truth and honesty and all about the right thing. I believe in that. But that really impacted me, and I just realized, you know, I don't want to be in this space anymore. Which pivoted me to, you know, I know a lot about the space. I did PIP plaintiff after that for a lot of my clients who I did corporate work for. And it just seemed like they said, look, you seem like you have integrity. Can you help me out with these and get them forward? You know, I wasn't really a big PI player for any means, but I knew about the business because I was involved with it. And that event of that young woman really like set a tone for me to think, maybe there's another way to do this. So with that being said, I think for the providers that do render the treatment and they do see these people, a lot of doctors go into this business, providers go into this business for the right reason, right? And it's to help people and to help them for their injuries. And just because the law's changing and this is happening, I don't think this is the end. I think that this is just a pivoting moment to realize, well, what do I got going on that's going to keep me in business and keep me doing the right thing, right? Fighting the right fight. So I think that if you're a provider who has commercial plans, I think you're going to be okay. Maybe the amount of reimbursement won't be as high as you once expected it to be. I think you'll be able to survive because, as you've seen now in the statute, that's the next place where you go bill is the commercial. And if they don't have commercial, if they're Medicare eligible or Medicaid, then you bill those. But ultimately, it's not the end, right? Something's going to have to give. I don't think this is the end also of the law. I think with a lot of these big law firms challenging these events, there's going to be edits to the law because it seems very one-sided right now. From someone that, you know, I don't have a stake in this game. I'm not a personal injury lawyer. I don't have a bone in this fight. But to me, it does seem unfair. And like I said, I'm all about righteous billing and doing it all right, but it's concerning.
Yeah.
Because will this limit the amount of care that a person can receive if they're really injured?
Yeah.
Sounds like that.
I think that's ultimately the effect that will be kind of the leverage point for legislators and for all the players at the table, which is at the end of the day, the people who stand to lose the most are not the lawyers and they're not the doctors, they're the patients. Yeah.
So I think that if you don't have commercial insurance, you know, you have to start thinking about what are you going to do to reinvent your business. A lot of calls I've been receiving from clients are, what can I do to stay afloat and to keep, you know, practicing? And I'm going to target chiropractors for a second because a lot of my clients are chiropractors. I represent a ton of them. And what I try to explain to them is possibly going into the cash model. And they're like, well, what does that mean? I've been doing PIP for 20 years. What do you mean cash? What does cash mean? Well, there is a law. It's called the Direct Primary Care Agreement statute that actually enumerates MDs, DOs, and chiros are in that mix, and they can create something called the Direct Primary Care Agreement, which essentially is a membership contract with a patient. It's not considered insurance. It's very clear that it's allowed and it's not considered insurance. You just need to comply with the statute and your contract needs to comply with the law. But ultimately what that does is people that need chiropractic services. And I think that from what I've gathered from a lot of my clients is that once you get chiropractic treatment, you kind of need it forever. It's one of those things that once you receive an adjustment, you got to forever get it. If not, your body will never assimilate correctly ever again. Once you've started to get those manipulations, it's like a muscle memory where it kind of needs it. So patients probably feel, well, I don't have coverage anymore. Can I even get this stuff? some commercial policies include chiropractic services, but as we've been talking, chiropractors, aren't reimbursed the most when it relates to commercial. It's hard for them because the reimbursement rates are not the best. So what's a good way to do it? Well, possibly doing it in a concierge basis, where you render your services, but you include other things that would be considered, let's say, not covered services, like being available to them under telemedicine after hours, having a 24-hour call line, a 1-800 number where if you're really if you're hurting, you can call, which is not like traditional in medicine. It's typically like you come in, you get an office visit, you get a follow-up, maybe you get a telephone conference for a follow-up. That's like traditionally how it works, right? But if you can implement these other things that are new in the world, like telemedicine, right? Or exposure to, I want to talk to my provider after hours through a text message conversation. What should I do? Should I take this? Should I take that? I think that this now segues to improvement and advancement in the space.
Yeah, we're surprised all the time with physicians of all kinds, but especially chiropractors, whose eyes get really wide open when you start talking about DPC opportunities for them. They had no idea. Some of them have heard of it, but they don't understand the extent of services that are permissible under a DPC contract. And I think you're right that you're going to see more migration into the DPC and concierge direction, because that's what's happening in the medical side anyway.
Right.
You've seen this bifurcation of insured versus cash paying, and insured has become something more of kind of exigent emergency services almost. Big ticket items get covered by insurance, and then wellness services typically don't. Mm-hmm. So there's this kind of rift that's growing, and I think it's getting wider of what's covered versus what people pay for cash for wellness.
Right.
So I think that tracks in the chiropractic space too,
right.
DPC.
Right, and our firm represents a lot of providers that are involved in IV therapy and they do med spas and things of that nature. And my colleague Chase Howard, he's the man to talk to about that. But Chase and I have been working on a lot of things together to service these kind of clients that want to maybe pivot into that industry. But he's using me and saying, maybe the stuff that you were already trained to do, like chiro services, you can get that for cash. And providers at times are like, wait, what do you mean I can do that for cash? And they don't understand it. So there's ways to platform to be able to do the things you were trained for, and then to be able to retain providers that can do med spa services, can do IV therapy services, like nurses, APRNs, MDs, DOs, and you incorporate them in your practice, and now maybe you're thinking more of, well, I'm not just a little chiro shop.
Right.
I'm converting myself to a group practice.
Right.
Which is where this takes me is the onset of that's where you need to go to survive. If you're not operating like a group practice, are you going to survive big medicine?
And that's why we're seeing traditional single specialty platforms like chiropractic bifurcate and trifurcate into HRT, regenerative medicine and stem cell exosomes, and all kinds of other wellness-based services. Because I think one of the things that chiropractors in particular learned is that they're really kind of the front door for musculoskeletal wellness. Yep. And the patients are going down the street to get these other services, whether it's HRT or regenerative medicine or IV hydration. And these chiropractors in particular and physical medicine physicians are saying, why are they going down the street to solve those problems when they could just solve them right here? Right. So they're kind of building out more expansive platforms that the patients want anyway.
Right.
Yeah.
Another observation I've made in my years in doing this is patients tend to follow the people they feel comfort with. In today's day and age, there's like a need for providers. There really is. MDs, DOs, APRNs, there's a need for them. And I think that in the primary care space, sometimes you don't get all that you need from your primary care doctor because they're in such a rush. They're seeing 30, 35 patients a day. They're going fast. They're really not taking the most amount of time, maybe just the legal amount that you have to bill. But that's becoming a problem where maybe your treatment or your questions aren't being fully answered.
Plus their training and their mindset is very specific to what they're doing as an internist or a GP or an FP or something like that. And part of their training isn't going to include hormone management
Right.
or joint repair with exosomes or Wharton's jelly or anything like that. They're just going to stay in the lane that they know so well, and that leaves patients looking for solutions outside their office.
So to segue into that, what I've seen is that in the chiropractic industry, patients will say, hey, doc, why don't you get someone that can help me with my primary care services in here? Can you maybe get somebody to come and maybe I can just keep all my stuff here? And what I've seen is a pivot where the chiropractic industry is basically developing into family medicine, in addition to med spa and IV therapy and all that. But that is a segue where maybe your survival will take you, because think about it. If you can say, we're going to provide you chiropractic services, but while you're here, you can also see the APRN or the MD, and you're sick or you need to get a follow-up on your prescriptions, one-stop shop. Now we're going into what the government's pushing, which they've been pushing forever. It's value-based medicine, right? So what's value-based medicine? Value-based medicine is patients can get all the services they can in a network for the least amount of time and effort, and you don't bill as much to the carriers, essentially. And it's basically there's bypasses to like the Stark Law and the anti-kickback law, where you can work and you can send referrals and it's not illegal as long as you're complying with the safe harbors and the exceptions. And now what that does is it provides more of a wholesome care. You see, the problem in the United States with medicine is we're a reactive country. We're not like, for example, Europe is a proactive, meaning that they are from the onset. They're trying to taper on like diabetic care, cardiology care, orthopedic care. They're doing it from the beginning. They're before you get into those ranges of years. Where here, we're kind of like, okay, if you're in this age range, these are the issues we're going to talk about, and that is it.
Yeah.
And what that does is it puts you in a box.
Right.
So then your care essentially is only based on these metrics, and they're not really looking at big picture. Providers are looking down in the book, but they're not looking up. I think the segue here is if you have group practices that have all these things encompassed, now you can provide overall care. The patient is basically the most beneficial out of all of these because they're getting everything they can in one place.
Yeah.
As a provider, now you have more services, and it allows you to basically keep your doors afloat because now you've just maybe doubled or tripled your book through your own services, through your own clients. You don't have to go now and start to look at, can I get more patients? You're working with what you got.
I think one of the things that you're especially good at, and that we're especially good at as a firm, is taking the challenges of the providers and showing them how their solutions are right in front of them.
Yeah.
It's just that they're not looking at it in terms of what's fully available. And I think that's one of the great kind of business consulting types of services that we end up providing because we've been taking care of physicians and healthcare businesses for so many years.
Yeah.
Yeah.
So, you know, what I and to end it, to end what I've seen as a relation to House Bill 837 is we have seen an uptick in SIU audits. Now that is a topic for itself, but I'm going to touch on it because I have an article that's coming out in a few days. So look out for that. It's going to talk a little bit about what an SIU audit looks like, what's the landscape that you need to be aware of, because I think a lot of providers aren't aware. With the enforcement of the law and now essentially the policing power that insurance companies have been given more than ever because of this law. I've seen that the SIU now is more than ever flagging claims. They're using algorithms to basically, if you start submitting certain claims, it's computer software. It's not like an actual person that's looking at your bill. They're flagging it. And if they show that you've inputted a code so many times in a repetitive manner in the same time frame, even if the client may have needed it, the patient may have needed it, they're flagging you and they're going to investigate you and they're going to ask you, well, why are you doing it like this? Why is that the way that you're doing it? And you may be right the way you're doing it, but you're still subject to having to answer their questions, having to sit for those interviews. And I think anyone that's being impacted right now or is being solicited by SIU for an investigation or an interview, they call it an interview. Seek out legal counsel. Do not make the mistake to go in there thinking, I know what I'm doing, I'm going to be okay, I got this. Get an attorney on the phone. Because the problem is, if you go down that road and you've now given up all this information, they're building a case against you that can be brought later down the road. Maybe not through the interview because usually, typically they enter them through these confidential agreements, but nonetheless, they now know the place to go find it. So ultimately, what you'll need is a skilled legal team to be able to navigate how those investigations should go, and to help you to understand where the next steps will take you
Right.
in those audits.
Yeah, well said.
Yeah. Thank you for joining us for our first episode with the Florida Healthcare Law Firm. This is Jeff Cohen. I'm Carlos Arce. We look forward to talking to you more about your legal needs.